Good morning. I'm Paul Truster, head of CLE at the Law Society, and I'd like to welcome you to today's program, the last CLE program of the century. If you here at the Law Society, if you hold that the new century begins in January. I apologize for the lateness, but we'll begin in just a moment. I'd like to begin by thanking our chair and our faculty who've given very generously of their time and talents in preparing the materials that you have and the presentations that you'll see and hear. We're obviously completely dependent on their efforts, and we're certainly very grateful for them. Speaking of the binder, you have it. It's complete. A few pages into that binder, you will notice a gray course evaluation form. And I apologize if you've heard me say this on many other occasions, but it's still true. We read each one of those forms once we get back. We take them seriously, and they do provide valuable insights that help us design programs to better meet your practice needs. And so you would be acting in your own enlightened self-interest, as well as doing us a very great favor if you could complete that form by day's end and leave it at the registration desk outside. If for any reason that isn't possible, then please do send it in by fax or mail or carrier pigeon or however it arrives. We'll read it and we'll consider it. I've nothing further to say except to introduce our chair of the day, sitting at my extreme left, James Morton, whose books, Limitation of Civil Actions and Procedural Strategies for Litigators, are quite likely on your bookshelves. His biography and those of the other speakers are found inside the binder, so I won't read them, but I will ask you to join me in welcoming James Morton. Thanks.
Thank you very much, Paul. I appreciate that very kind introduction. Today we have quite a stellar panel of senior litigators who are going to be talking from a practical standpoint about the application of a theory of a case. And I won't tread on their topics except to say that it's very clear that unless you have a theory of a case and unless you know what the other side's theory of a case is and can meet it, there's very little chance that you can be successful in litigation. And with a good theory of a case, on occasion you can even win a less than, well, let's just say a challenging case. The first speaker we have today is very well known. He's Martin Sclisizzi. He's been a prominent litigator with Borden Elliott for many years. And he is going to be giving us an overview on how and why to develop a theory of a case. So I'll turn the floor directly over to Mr. Sclisizzi. Thank you.
You'll have to pardon me, I'm laboring under a bit of a cold this morning. Ladies and gentlemen, it's April 25, 1995. At around 4 p.m., John Smith was walking along Spring Street, just around a corner from his home. Suddenly, a car came from behind, ran through a stop sign, made no attempt to stop, slow down, or swerve, and crashed into John from behind. John didn't know what hit him. The impact crushed his ribs, broke his back in 2 places, and threw him into a ditch. Those were the last steps John Smith ever took. He will never walk again. This is from an opening statement taken from Thomas Mewett on trial techniques. The theory and the theme of this statement was not developed at the last minute, just as counsel was about to walk into the court. They were developed long before trial. They were carefully thought out and planned with an appreciation of the basic principles of the psychology of persuasion, and with those principles clearly in mind. Every case, regardless of complexity, must have a theory and it must have a theme. A case without a theory is like a rudderless ship drifting aimlessly through the litigation process without focus and without direction. A case without a theme is like a story without a moral. Both the theory of the case and the theme must be developed early in the case, and I'll explain to you why as I take you through this. You should begin developing both the theory and the theme of the case the day you are retained, and this is especially true of the theory. What is the theory of the case? Well, the theory is more than counsel's game plan or counsel's strategy. It's more than counsel's position and approach to the evidence. It's more than just a legal theory. It's more than the legal elements and the causes of action or the ingredients of the defense or the claim, and it's more than a combination of the facts and the law. The theory of the case is a clear, simple story of what really happened from your point of view. The theory of the case is the adaptation of the story to the issues, to the legal issues in the case. It must be consistent with the undisputed evidence, as well as your side's version of the disputed evidence and the applicable substantive law. It must not only show what happened, but it must also explain why the people in the story acted in the way they did. It must be directed to prove every legal element that is necessary to justify the verdict in your client's favor. It must be a persuasive story that will be the basis of your evidence and arguments throughout the trial. It must be logical, simple, plausible, understandable, and accord with common sense and the concepts of fairness and justness. You should be able to state the theory of your case in a single paragraph. And if you can't express the theory in a single paragraph, then it's probably too complicated and it needs to be revisited and defined or refined. How do you develop the theory? The theory of the case obviously needs to be developed as the facts unfold, but it needs to be developed well before trial. The starting point for developing the theory is a thorough investigation of the facts, an identification of the issues in the case, the identification of the evidence available on each issue, and a consideration of the applicable law. Your version of what really happened is a process that begins when the case starts and steadily develops and evolves as the case progresses through to the discovery stage. By the time discovery is complete, you should have a good grasp of the undisputed evidence, the evidence in dispute, and what key factual disputes there are. By this time, if not sooner, you must decide on your theory of the case. Preparation for trial is not the time for deciding on the theory. Preparation for trial is a time for focusing on proving the theory. It's a time for deciding what witnesses will be used to develop and enhance that theory. It's a time for deciding where each witness will fit into the enhancement and the development of the theory. The development of the theory requires a number of steps. First and foremost, as I've said, is a thorough preparation of the facts. The investigation must include not only a detailed interview with your client, but also an interview of all witnesses or potential witnesses both adverse as well as favorable, and a thorough review of all documentary and physical evidence. Secondly, you must review the elements of each claim or defense and analyze how you intend to prove them or disprove them. And this will include an analysis of the admitted facts, those facts that are readily provable, and the facts that will be hotly contested. Thirdly, you must consider each side's strengths and weaknesses to determine how you can bolster any weaknesses in your own case and how you can effectively attack your opponent's strengths or take advantage of your opponent's weaknesses. At the investigation stage of the case, one of counsel's principal goals is to identify every conceivable theory of the case. During this stage, you do not wish to make a premature diagnosis. Counsel may have several theories of the case, some that complement each other and others that may be inconsistent. As the investigation continues, as the witnesses, both favorable and unfavorable, are interviewed, and as the documents are carefully examined, theories will be discarded or jettisoned. One of the functions of the pretrial proceedings is to eliminate theories lacking in legal and factual merit. Certainly, by completion of the discovery stage, all theories lacking merit, either factual or legal, should have been eliminated. Discovery serves as a fact filter, if you will, for theories, and results in the elimination of those theories lacking legal or factual merit. Counsel's task would be simple if at the completion of discovery there's only one theory remaining with both legal and factual merit. Unfortunately, or however, frequently this is not the case. Particularly in complex litigation, even after thorough discovery, several tenable theories may remain. The theories may complement each other, or they may be inconsistent. The question then arises is whether counsel should take multiple theories to trial. The initial impulse might be to do so just to be on the safe side. In my view, there should be only one theory of the case. It's inadvisable, in my view, to take multiple theories to trial when those theories are inconsistent, especially when the trial is by a jury. In their law school training, and in our law school training, lawyers and judges are comfortable with the even if or the alternative arguments. However, juries generally find such arguments curious and suspect. Jurors have difficulty in accepting conflicting theories in the alternative. Certain theories may complement one another. For example, in a negligence case where numerous allegations of negligence are made, there may be several theories. The several theories may complement each other and cumulatively paint a powerful picture of negligence. However, even with consistent theories, I caution counsel to be cautious. Urging several theories may confuse. Urging secondary theories may weaken or detract from your primary theory. One theory of the case is the most consistent and the most understandable way of presenting a case. While judges are trained to deal with multiple theories, pressing several theories creates a danger of confusion in the minds of a jury. The theory of the case will affect tactical and strategic decisions made by counsel at almost every stage of the case. Thus, it is important that the theory be formulated early. Tactical and strategic decisions made early in the case may have significant consequences. Some tactical and strategic decisions may be difficult, if not impossible, to reverse. And even where the decision is irreversible, the chances of success may be enhanced, and considerable time and expense may be saved by a sound choice of initial tactics and strategy. The early development of a theory or theories of the case will influence or impact many pretrial steps and proceedings, as well as the tactics and the strategy which you may adopt. The parties, the pleadings, productions, the oral discovery, settlement strategy, witness preparation, as well as other tactical and strategic procedures may be affected by the theory or theories of your case. Who should be parties and in what capacity they should be parties is a question that counsel needs to consider in every case. However, the theory of the case also has a bearing on who those parties should be. This will entail an analysis or a consideration of whether or not the addition of a party or parties enhances the theory or will detract from the theory. The theory of the case, as well as the nature of the claim, is a factor which determines or should determine not only whether there should be multiple plaintiffs, but also multiple defendants. For example, counsel may want to consider whether corporate officers and directors should be defendants along with the corporate defendant. Counsel will have to consider whether the facts and the theory of the case support a claim founded in fraud or other tort against the corporate officers and directors, giving rise to a claim in their personal capacity. There must be a sound factual basis for the inclusion of the individual defendants, and their inclusion must be in keeping with the theory of your case. Some theories and themes lend themselves to effective extra-legal maneuvering. A particularly resonant theory and theme may lend themselves to motivate the opposite party through adverse publicity or merely the risk of adverse publicity to a speedy resolution of the dispute. Where the facts of the case are particularly egregious, or the plaintiff is a particularly sympathetic party, adverse publicity or the mere risk of it may bring about the desired result. Some businesses, such as financial institutions, which highly value public trust and confidence, may be particularly adverse to adverse publicity and therefore quite susceptible to a resolution of the dispute long before trial. The theory of the case, or your theory of the case, as well as the character and personality of your client and the nature of the claim, are factors which you may wish to take into account in deciding whether your client is better off as plaintiff or a defendant. And there may be instances where your client's story and counsel's theory of the case will have its greatest strength and will be the most persuasive after the other side's version has been told. The starting point for trial preparation is developing a coherent theory. This theory should be reflected in the pleadings. The pleadings are the roadmap for production, they're the roadmap for discovery, and should define with clarity and precision the legal and factual issues in dispute. The pleadings are the first document that the judge reads, and therefore it's counsel's first opportunity to put forth the theory of the case. Pleadings, whether statement of claim or statement of defense, should tell the party's story and reflect the party's theory of the case with conciseness, precision, brevity, and consistency. Very early in the case, even before pleadings are noted closed, counsel has to decide the fundamental tactical question of whether the case should be tried by judge or by jury. A number of factors need to be taken into consideration before that decision is made, including the nature and character of the parties, the nature of the claim. Another factor is the theory of the case, and whether it is easier to sell that theory to a judge or to a jury. Discovery is affected by the theory. As I said earlier, discovery should act as a fact filter of theories and should result in the elimination of the theories lacking legal and factual merit. It should also lead to a scrutiny of those theories that may be difficult to prove. As well, discovery provides counsel with the opportunity to develop and test the theory of the case. Through a thorough and focused examination, counsel is able to develop and test the theory of his own case or her own case. Similarly, the examination of your client provides the opportunity to test the theory of your case and demonstrate whether your client is convincingly able to sell that theory either to a judge or to a jury. Trial lawyers must have sound knowledge of substantive law, procedure, and of the rules of evidence. However, that's only the beginning. Trial lawyers must also have an understanding of the psychology of persuasion and how to apply that psychology effectively in the courtroom. Counsel's role is to present to the trier of fact a credible and persuasive story. There are a number of psychological principles worth noting which play an important role in the art of persuasion. Effective oral advocacy requires an appreciation of these principles and the adaptation of counsel's presentation of the story with these principles in mind. First, there's the principle of primacy and recency. Primacy and recency refers to the widely accepted phenomenon that people tend best to remember things they hear first and last. The law of primacy states that you should present the most important points of your case first, because they will have the greatest impact and will burn the sharpest image in the minds of the trier of fact, especially jurors. this principle must be borne in mind throughout the trial. It applies to the opening statement, to the examination in chief, the cross-examination, and to closing argument. The next principle is that most people's attention spans are short. The average person can only maintain a high level of concentration for about 15 to 20 minutes. We've been at this about 20 minutes now, so I'll bear that in mind. Next, memory is fleeting. The average person forgets most of any communication within a few hours, and after several days retains only a small part. It makes no sense to communicate if the listeners do not retain the essence of what has been communicated. Trial counsel needs to understand that memory is fleeting and must adopt strategies to improve the trier of fact's retention of key information presented during the trial. The next principle is that repetition is a powerful influence. Research has shown that repetition can be used to increase memory and therefore persuasion. Storytelling is the way people have communicated with each other since the beginning of time. And a trial is no more than telling a story. However, trials involve much more than merely introducing a set of facts. Those facts must be organized and presented as part of a memorable story. Good stories organize, harmonize, and dramatize. They have a plot, they have characters, they have emotion, they have a theme, they have a moral. It is as a result of the psychological principles that I've just mentioned that the story presented to a jury and to a judge as well, to be memorable and persuasive, must have a theme. Just as every case must have a theory, in my view, every case should have a central theme. Like effective advertising, a case must have a theme. Just as a theme in advertising brings specific and distinctive quality and character to a product and provokes product identification, the theme of the case, or the label, if you will, or the moral of the story, does the same thing. An effective theme appeals to the judges or the jury's sense of righteousness, duty, and community. It helps the jurors and judges to understand events, to pay attention, and to remember key facts. While the theory of the case appeals to the judges or the jury's intellect, the theme appeals to the emotions. Themes are the memorable words or phrases that encapsulate the essence of the case and project the image that you want the judge or the jury to retain about the case. There are no hard and fast rules on building a theme, just as there are some rules about building a theory. And the reason for that, of course, is because no two cases are ever alike. However, there are a number of common characteristics of an effective theme. An effective theme must be unique to the case. It is logical and consistent with the judge's or jury's concepts of fairness and justice. It is consistent with and supported by the evidence. It is easy to remember, it's easy to repeat, and it's easy to integrate throughout the course of the trial. theme should be emotionally compelling. It should incorporate the trier of fact's sense of fairness and universal truths. It should be simple and have immediate meaning, and it should focus on people, not on issues. A theme that is easy to remember and easy to repeat contains memorable words and phrases. It stands out and it focuses attention. For example, this is a case about greed, or this is a case about misplaced trust. As I mentioned a moment ago, research has shown that repetition can be used to increase memory. A theme helps jurors remember the evidence. It makes the key information easier to retain and to retrieve. Repeating a message, such as a theme in opening statement and in closing argument, several times substantially improves retention. The trial is the playing out of the theory of the case, which has been developed well in advance of the trial. If the trial is to be a persuasive story, the theory and the theme must be woven through every aspect of the trial, from the opening statement to the final argument. It must be incorporated in the examination in chief and in the cross-examinations as well as the opening and closing arguments. You will need to know what impression you want to create in the mind of the trier of fact. The order in which witnesses will be called to give their evidence and the preparation of those witnesses will necessarily be different depending on the theory, the theme, and the atmosphere that you wish to create. The opening statement is a crucial stage in the trial. The opening statement is counsel's first opportunity to speak to the judge or the jury, and although the opening statement to a judge should take a different form than the opening statement to a jury, the opening statement to both should present a coherent theory of the case and introduce the central theme. The opening statement will be your first opportunity to tell the judge or the jury what the case is about. As such, it is a critical part of the trial that must be carefully planned, developed, and delivered. There have been many books and texts written on opening statements and closing statements, and I don't propose to say very much about them, but the single most important rule concerning opening statements is to present a coherent theme of the case and introduce the theme. First impressions become lasting impressions, and therefore the first few minutes of the opening statement should unfold your theory of the case and state your theme. An effective opening statement uses the central theme of the case to persuade. While the theme should be introduced in the opening statement, counsel, of course, has to be careful not to overplay it so that it constitutes argument, which we all know is prohibited in opening. In closing, however, the theme should be constantly present. Effective opening statements to juries usually have 5 components. The first, a brief introduction to warm up the jury. In my view, that's an optional one. 2, an impact statement that capsulizes the theory and the theme of the case. The third component, the story of what happened. The fourth, an explanation of the legal claim or defense. And the fifth component, a conclusion that brings together the theme, the theory, the story, and the claim or defense for a just verdict. An effective impact statement has been described, or has been compared, I should say, to a good lead in a newspaper story that engages the reader. It should outline the theory and the theme of the case and set the tone for the ensuing story. An impact statement is designed to invoke the psychological principle of primacy, which I referred to earlier. The conclusion of the opening statement is designed to invoke the principle of recency. A memorable conclusion should bring together the theory, the theme, the story, and the legal claim or defense in a powerful ending. Finally, ladies and gentlemen, let me just share this with you about the evidence. In English law, there once existed a remedy called the petition of right. By it, a subject could have redress for a wrong done by the king or his ministers. When such a petition was endorsed by the Attorney General, he wrote on it, "Let right be done." This lawsuit is a petition to you for redress for a life wrongly taken. As the evidence unfolds, you will hear how this defendant company knew that these electric blankets were a hazard waiting to ignite, how the defect was covered up, how the company violated not only industry standards, but numerous federal regulations, how this defendant took the company into its own hands, and with it, a young child's life in a death by fire. So, ladies and gentlemen, when the time comes for your verdict, let me simply ask, let right be done. This is an example of the conclusion of an opening statement taken from Herman and Winston and Enter Opening Statements, Staging the Case, in the July 1995 issue of Trial Magazine. You be the judge, or rather I should say, you be the jury as to whether this is an effective conclusion. Thank you very much.
Thank you very much, Martin. And I must say that at least one of your lines will find its way into my opening in a summary judgment next week. This is a case about greed. I love it. Our next speaker is Mel Solmon, who I think is well known to at least many of you. I had the privilege of working with Mr. Solmon some time ago, and he is a very prominent and well-known lawyer with very great expertise in the rules and strategy. And I'd ask Mel if he could come and speak to us now. Thank you.
Good morning. There has been very little written about pleadings. You might wonder, why would anyone want even write about pleadings? They're so easy to deal with. There's nothing much more than putting the facts down. The last article that I was able to find that had any comprehensive basis, pleased to say, was written in 1901 and is found in the Canadian Law Times at page 143, and it's actually more than 3 or 4 pages compared to everything else I found that's been written about pleadings except for some texts. And so obviously the task of trying to write about pleadings is something that is rarely done, and probably for good reason. But my theme or theory to you today is that the pleadings are going to become probably the most important document during the course of all litigation in the new millennium. And that's because we're in case management, and judges don't have time to read the pleadings twice. And if your pleading is archaic and does not flow properly, uses archaic language and complex sentence structure without presenting a theory up front, I don't think judges will have the patience to deal with the many cases that may arise as I see it in the millennium. And so my theory to you today is that the theory of your case should be put up front in the pleading. It is not prevented by the rules, and it may very well be the selling point for you to market your case right from the beginning. The amount that's been written about the theory of the case in articles is almost parallel to what has been written by judges. I have done the Quick Law search and the E. Carswell search, and there were 249 hits for the words theory of the case. And I didn't search plaintiff's theory or defendant's theory or Crown's theory or defendant's theory and criminal accused theory. But from those two searches, I found that there were 249 hits in Quick Law and 174 hits in E. Carswell, and more than half of them were criminal cases, and more than 25% dealt with the theory of the case law. So it really wasn't your theory of the case. So that very little has been written about it, even by judges. And then I tried searching the word theory within 15 words of the word pleading, hoping that maybe somebody will give me some hint that I'm not treading on something that is totally brand new. And the answer was there was one case, which I'll get to, and it was a defamation case, and it was not very helpful. So I'm going to suggest to you this is not a dry topic, that what it is something that can hopefully help you with both your presentation, your case in the end, but most important in the beginning to sell it. And every once in a while I may interrupt myself because some of the examples I intend to use hopefully are the kinds of things you should be doing in trying to develop your theory. For example, some may think that a theory is a preliminary sketch of a Rembrandt painting, where all the details and the color and the choice of color and the shading fit into that sketch. That's the evidence and the witnesses. But the theory is the sketch. The theory does the same thing. It places your whole argument together in one cohesive unit, so when you look at the picture, hopefully it's beautiful and persuasive. Why is it so important? And why do I believe it would be important? Because marketing of your case and persuading the judge is the essential element of what you are doing. You are marketing. And in marketing, you have to determine the important words and the important thoughts that will sell. Now, where is the theory used, the pleading used? The pleading is used throughout. I find the pleadings most helpful on interlocutory motions. And you're going to be hearing about that. But if your theory is up front in your pleading, it'll be easier to get production of that document or to get that question answered by the witness that was refused. And at pretrial, in case management, at trial conferences, if there's something that the judge can look at quickly and say, aha, I understand this case right away, then that is the kind of thing that hopefully you'll then get a reputation for, saying, this counsel is not afraid to put their theory up front and deal with it so that I know exactly what this case is about quickly and easily, and therefore it saves my time. I'm now talking like a judge. All right. This paper tries to suggest the benefits and how to formulate your theory and why it has these great advantages. and how, if you take the time and effort, in the end, it will be worthwhile. As Marty has said to you already, theory helps you remember everything. You can take all the detail, pages and pages of documents, but if it all blends into and reconciles with a theory, then it is easier to sell. So in summary, my theme or theory to you today is, number one, why is it a good thing to plead your theory? Number two, what it is and how to do it so you can formulate it for your pleadings early in your case, and why it will survive a motion to strike. What judges, I think, will think about it, and hopefully they'll get the idea if you only have to read the pleading once, then it saves judicial time. And you're talking about 1,000 cases a year. If you only have to read each pleading once, think about how much time they save. Now, the theory of the case was first mentioned from the Quick Law Search in 1898 in the Supreme Court of Canada. And I can tell you that it's not even worth mentioning. But what I intend to do now is to try and tell you where the theory of the case has been mentioned in some of the cases that I found, because it is becoming, believe it or not, a very hot topic. In fact, in the Supreme Court of Canada in 1998, it cited 1998 3 SCR 262 in the Queen and Rose. The Supreme Court of Canada had to deal with the issue of whether or not it was fair for the defendant to be able to reply to a jury address by the prosecution when the defendant didn't call evidence. As you know, if a defendant doesn't call evidence in a criminal trial, then that defendant has to speak to the jury first. The Crown goes last. And if you don't know the theory of the case from the presentation of the opening and the evidence, then when the Crown gives the theory, the closing of the accused may have left out some of the points necessary to answer the Crown's theory. And the issue was, could the accused reply? And the Supreme Court of Canada said 5-4, no. They said the theory of the case should have been discernible, in effect, and that it didn't breach the charter. And in doing so, of course, they talked about the theory of the case and what it is. The other case that I found that I thought was very helpful is a decision of Mr. Justice Crindle in the Manitoba Queen's Bench, 1999, Carswell, Manitoba, page 457. It's the Queen and Hangman, again, a criminal case. And in that case, which is about a year after the decision of the Supreme Court of Canada in Rose, the accused tried to get disclosure of the Crown's theory of the case and brought a motion saying, yes, the Queen and Stinchcombe gives me the evidence and the documents, but I want to know the Crown's theory. And Mr. Justice Crindle held no. And in doing so, he talked about what the theory of the case was. And he referred to Mowat, which is referred to in our paper, and he referred to Stoicer on an advocacy primer. And he talked about the game plan and how it's fluid and changes. But otherwise, what has been really written about the theory of the case by judges and how they used it? Well, one example is the case of Bank of Boston versus Scarborough, 1994-17, Construction Law Report, second series at page 137, where Mr. Justice Winkler said, the plaintiff's theory of the case was that Scarborough was delaying in paying the account, and there was no merit to their defense. And he found that that theory of the case, the plaintiff was glued to like crazy glue and would not leave it, even in the face of an expert's report provided by Scarborough, which clearly showed that there was justification that the product that was used was inferior. And Mr. Justice Winkler ordered solicitor-client costs from the point in time where the plaintiff should have realized that his theory of the case was wrong. And so, and Mr. Justice Winkler referred to the theory of the case and how the plaintiff should have realized that his theory was all wet. Another situation was in the case called Hodgkinson and Road in 1996, Ontario Journals 1368. Mr. Justice Ferguson dealt with the theory of the case presented by the Tenants' Counsel, and he had this to say. It was apparent that the case was poorly prepared, and the Tenants' Counsel had not thought out his client's theory of the case. It appears he did not do his research until the last day of trial when he asked for a recess for that purpose. I won't tell you what happened with costs in that case. You won't want to know. Madam Justice Bell, in the case of Ferguson and National Life, 1996 Ontario Journal at page case number 1329. In that case, the defendant raised a new theory in the midst of trial, and the new theory was that the disability benefits were caused by the misdiagnosis of certain doctors who had already taken the stand and had even been cross-examined on the point. And Madam Justice Bell said that this defense was not in the pleadings nor in the defendant's theory of the case produced to me earlier, and she disallowed the amendment to the pleading and that the issue should not be considered by the jury. In a case that was dealt with by Madam Justice Arbour, called the Toronto Industrial Leaseholds and Possessorski at 1989 Ontario Journal, page 1810, the theory of damages that was put forth was different than what was pleaded, and an amendment to the pleading was not permitted. In federal court, in dealing with patent cases, they had to deal with the theory of the case and determining what questions should be answered, and Madam Justice Reed had this to say about a case where she was asked to determine if a question should be answered, and she said, "It is often difficult to know whether the answer to a question is relevant before one knows what the answer is and how it fits into the defendant's theory of the case." All these cases that I've referred to, I suggest to you, suggest that the theory of the case may be of assistance throughout the litigation process. And if it's in your pleading, the one written document the court has both before you walk into the motion and during your motion, and then of course after your argument, then that is the document that should be carefully drafted and be thought of and be dealt with properly. Notice that I was wondering if some judges had any thoughts about pleadings, because some people think pleadings are a casual thing, and I found a nice little quote from Mr. Justice Riley in the Dooley case, which is found in 19 OR 3rd at page 779, where at page 788 he talked about pleadings, and he was dealing with a cause of action where someone pleaded intentionally defenses that they knew were fabrications and not true, and the question was whether or not you could sue someone for doing that, not the lawyer, but the parties who told the lawyer these fabricated defenses, and the answer was no, that's not an abusive process unless there's some overt act or threat before you commence the action that is an abusive process, but it's not an abusive process from a tortious point of view. And he had this to say about pleadings. First of all, about statements of defense, I thought was interesting. He said, as a matter of common judicial experience, pleadings, particularly the statement of defense, are less than totally accurate. I say particularly the statement of defense because the rules require its creation often before counsel for the defendant has an opportunity for full and accurate preparation. That is why there's a considerable flexibility to amend pleadings pursuant to the rules, subject, of course, to real prejudice to a party. Even at the commencement of trial, most judges will require counsel to clarify their pleadings, to confirm what the real issues are. Most inaccuracies are relatively innocent and may be tolerated. However, counsel may well gain a reputation, positive or negative, as to the accuracy and worth of their pleadings. And then he went on to talk about what kind of controls there are for doing pleadings that are improper or fabricated, including sister-client costs and discipline. And in the end, he said, finally, at the risk of seeming unduly naive or idealistic, I still believe that the best protection the public has from defamatory or otherwise tortious pleadings is quite simply the high ethical standards of the legal profession. With rare exception, those who practice the bar may be relied upon to draft their pleadings, if not always wisely or well, at least in good faith, with no intent to claim damage without just cause. I am confident my faith is justified. And so what I hope to do is help you develop your reputation in doing pleadings that will help you and the judge and gain you the reputation of being the kind of person who does do accurate pleadings that are helpful to the court in the very short period of time that I have. The one case that did talk about pleadings and pleadings and the theory of the case is a case called Kwan and Creighton, found at 1990, 107 NBR 2nd, at page 392, and that referred to the one text that deals with theory and pleadings, and that's the text of Mr. Brown on the law of defamation in Canada. And he was talking about pleadings related to defamation, but I think what he said is helpful with regard to all pleadings. The parties are entitled to plead all those facts they would be permitted to prove in support of their action or defense at trial. They should disclose all those facts essential to that cause of action. They must define the issue which is being tried and provide sufficient information to the other party as will enable him upon reading them to form a fairly correct judgment as to their scope and meaning and as to what is intended to be relied upon under them. They should precisely define the areas of agreement and disagreement so that the issues may be more expeditiously settled by the parties or decided by the court. The parties are bound by their pleadings and any admissions they may contain, and can adduce evidence at trial only insofar as that evidence is consistent with the theory of the case reflected in those pleadings. Now, what kind of pleading would you like? Would you like a pleading that it takes a surgeon or a miner to try and determine and pick away the chaff and see where and what is the theory? Or would you like to have a pleading where the theory is up front and center without any games being played, and it's there for you to sell, and without any doubt in the judge's mind or in the opposing party? Now, I've given you one example of how to describe a theory using the Rembrandt painting. Another way I might do it is, let's say you saw a bunch of people carrying around wooden sticks with skates on, chasing around some black little disc, and whistles go, people going on and off this arena, and you have no idea what's going on because you have no context. What is the context? If someone says to you, the idea is for one team that all wear the same color to get that little black disc in the net more times than the other team, and to prevent the other team from doing so. Now, everything that's happening on the ice is understandable. It has context. The theory of the case does the same thing. If the theory of the case is up front, it will explain the detail and the context in the pleading. So when you read the mumbo jumbo, the first thing I always say in a pleading is, oh, geez, what is it? I got to sit down with a pencil and paper and read it carefully and go through it and understand what is really going on in the pleading. But if your theory is up front, then it'll be much easier to read the pleading and understand it. Now, how to develop your theory. And part of this is in my paper at page 8 and following. But the first thing you have to do, obviously, is you have to put together a chronology. You have to get the information in chronological order, all the information, not just from your client's perspective, but from all perspectives. But I want to caution you that the most important time you're going to hear about the case is the first time. And when you are hearing it for the first time from your client, write down the questions that came to your mind as you were asking the questions of your client and hearing the story. Because your initial impressions and the questions you had are the same kind of questions that 2 years from then you're going to have to deal with a judge hearing it for the first time. And you're going to say to yourself, what were the questions I asked? And if you don't write them down from that initial interview, you won't remember, because you'll have 2 years of learning and information and documentation. So that's the first point. The second point is, when you get your chronology, and you get all the information from various witnesses and documents, and you put your chronology down, and make sure it tells a story, and make sure every fact fits together. And if there's something missing, try and find out what it is. Once you've got your chronology, then you're ready to do your analysis of the good facts and bad facts. That is, what are the things that, if you look at those facts, those are the things that you say, that will help my case. And then you look at the bad facts and say, how do these facts hurt my case, and can I explain them somehow? And as you work through that analysis, you're going to develop a theory of the case that will take your good facts and sell them as best it can, and take the bad facts and say, I can explain them. They're now understandable. And if you can't explain one of the bad facts, either your theory is wrong, or you better settle. Okay. All right. The questions I often ask while I'm doing this kind of analysis are, what happened? That's the chronology. why did it happen? That's looking at each person's perspective. Now, it's not easy to do that, right? Because you get your client's perspective and you're married to it and you're paid to sell it. But good litigators say, okay, I've got the client's perspective. Now let's look at it from the other perspective. You know, if you look at Goldilocks and the Three Bears, you can look at it from Goldilocks' perspective. But if you look at it from the Three Bears' perspective, it's a totally different story. They went out, had a nice picnic. They came back home and their house was a mess and there's somebody there. Broke the chair, you know, messed up the place. So each perspective is different. And the important thing is to try and get your client's perspective as the most persuasive perspective in the pleading. And after you get why did it happen, then you want what approach explains your client's conduct, and what approach explains the other party's conduct, and in the end, why does that suggest that your client should win? Now, in the paper, I've put down for you a number of thoughts at pages 6 to 8, which came from an article on the theory of the case written at Temple University. It's the only article I found that actually dealt with it in detail, trying both to explain and teach the theory of the case. And it gives you 10 points that you should try and follow in developing a theory, and I'm not going to read them to you. But I was going to go to an example. And before I turn to the example, I wanted to talk to you about choice of words, because I find that you develop your theory by choosing the right words, the words that in one or two words describe the facts. And as Marty mentioned to you, using the word, for example, the greed concept, that's the start of getting to your theory. But your theory may go a little beyond just greed. It might go to some kind of factual legal framework. And the only way to describe this kind of thing is to give you some examples. But let's first deal with choice of words. You want the judge to savor your pleading, to eat it up, to chew on it, to digest it, to easily enjoy every part of it so that at the end it will satisfy his or her sense of justice. And what images are your words evoking? Is the image the kind of image that will sell? And so my points that I think are, number one, words create images. The choice of words must be from your own personal experience because you understand the words that you've had personal experience with. They must be simple, obviously, to persuade. Simplicity is a key element. The image creation with persuasion evokes feelings, and those feelings hopefully will be feelings of fairness and justice for your client. Dr. Loftus, who is a well-known psychologist at the University of Washington, conducted experiments to determine the effective choice of words in a question and answer. And I say the same would apply to a pleading. She showed a film of an intersection collision to two groups of students, and both groups were asked to estimate the speed of the same car. Group 1 was asked, how fast was the car going when it smashed into the other car? The second group was asked, how fast was the car going when it hit the other car? Now, what do you think each group said? The group that was asked the question, smashed, said the speed was 40.8 miles per hour. And the group that said hit said the average speed was 33 miles per hour. Why? The key was the verb smash. That's the only difference. And what did that word connote or evoke? Greater speed, force of impact, recklessness, much different from the word hit. Will the choice of words affect how a judge or a witness may react? The answer is, of course. It's unequivocal. Aristotle was the first to observe that our thought process involves imagining what we think in terms of images. He said that you cannot create an image without thinking, and conversely, you cannot think without creating an image. The choice of words will affect the reconstruction of a past event in the minds of any individual, because the meaning we assign to words when we check them against our frames of reference will inevitably incorporate a value judgment. And then Marty mentioned the order of words. I'm not going to repeat it, but they found that if you said an individual was envious, stubborn, critical, impulsive, industrious, and intelligent, and then you asked another group and said the same adjectives in a different order, intelligent, industrious, impulsive, critical, stubborn, and envious, the ones who heard the positive words first thought he was a pretty nice guy. And the ones who heard the negative words first thought that he wasn't that nice a guy. And so when you choose your words, make sure you choose the words that you want your trier of fact to remember throughout the case. So, what kind of catchphrases can you use and where do you find them? Obviously, the easiest place is a dictionary or the thesaurus. If you have a certain idea of a word and you check the thesaurus, you might find different variations. The other place, of course, is cases. And cases develop language. And I think the best example is one of my favorite cases called the Bank of Montreal and Wilder. I do a lot of banking litigation work. In the Bank of Montreal and Wilder, the Wilder family had a business where they paved roads, construction company, and they had a relationship with the Bank of Montreal that was ongoing, and they had developed an initial agreement with guarantees, and they loaned a bunch of money. And then they got into a project. In the midst of the project, they needed more money. And they had a meeting with the bank, and it was an oral meeting without written confirmation. At that meeting, the evidence was found by the trial judge that the bank said, we will give you enough money to finish the project, but you've got to give us more guarantees and collateral security over the insurance policy over a certain person's life. And they provided all the security, signed the documentation. Of course, each of the guarantees were standalone documents and said, basically, the bank can do anything they want. And the bank did. They didn't provide all the money. The road wasn't finished. The company went bankrupt. A receiver was appointed. And the bank sold the assets. There was a deficiency, and they sued the Wilders. You notice the short little, crisp little sentences? That's the theory of the case coming up. Okay? So what happened was the Wilders, the Bank of Montreal sued the Wilders on the guarantees, and the Wilders' defense was that those guarantees that attached later with the collateral security were all part of an umbrella or overall loan agreement. Umbrella or overall loan agreement. Think what those words connote. They connote an overall agreement that the guarantee is just one small part of. And so what happened was that they sold that concept. And when they sold that concept, the Supreme Court of Canada in the end said, yes, the overall loan agreement encompasses all the documents. We know that the guarantee says the bank can do what they want, but they can only do what they want. That must mean legally. And therefore, looking at the whole agreement, they breached the whole agreement by failing to provide the monies. The guarantees are invalid, and the insurance money of the person who happened to die during this whole time period went to the Wilder family instead of the bank. But the point is the choice of words. The overall loan agreement, or the umbrella loan agreement, a catchphrase that sold that case. And it tied in all the facts and took all these all the facts related to the guarantees that seemed to be outside or separate agreements, or anyways, the bank tried to argue they were standalone, of course. And once the court adopted the theory of the case based on an overall loan agreement, then the Wilders were successful. All right. So I say there's magic in words. Things, you can say someone converted money, or you can say they stole it. You can say someone yanked the child out of the person's arms, or took the child out of the person's arms. Each connotes a different kind of activity and a different image in your mind. Another way to develop your theory is to play your ideas off another person, preferably not a lawyer, because a lawyer has all sorts of background baggage. But if you can, speak to individuals who are your friends, wives, relatives, and grandfathers, fathers. Tell them your story. See if it sells. See if the words you use connotes the same images you think they should to the person. See what questions they ask. And that helps you develop your theory of the case. But you do that before you draft your pleading. If you take the time to do it before you draft your pleading, then your pleading will be a selling feature. Another place you might get words are from ads. I was driving along the other day and I heard Don Cherry selling insurance, and he said that so-and-so they'll save you a ton of dough. Think of the image a ton of dough creates in a person's mind. And that kind of image, which isn't going to sell a pleading, but maybe it might be appropriate in some other case, you never know. All right, I have an example in the paper starting at page 9, the first example. I'm going to go to two examples. And the first example deals with a very simple case about widgets, and I still don't know what widgets are after all these years of law. And the facts are at the bottom of page 9. It says, the plaintiff enters into a contract on August 1st, 1999, and with the defendant for the supply of 1,000 widgets. The plaintiff manufactures computers. The defendant is the only supplier of widgets in Canada. The widgets are essential components of the computer. The defendant was to deliver the widgets by December 1st, 1999. It didn't do so. The plaintiff can't deliver its new computers for January 1st, 2000. And the defendant knows the plaintiff needs those widgets by December 1st. The defendants know the plaintiff cannot obtain the widgets elsewhere. It knows the defendant may be merging with another company that manufactures the same computers as the plaintiff. The theory is the defendant purposely failed to deliver widgets, knowing the plaintiff couldn't deliver the computers because it would not get widgets elsewhere, and therefore the defendant could get an economic advantage. The defendant could get an economic advantage. That's the kind of wording you're going to try and work on to find your theory. So, as I've said in page 10, the relief can be claimed as $1 million in damages, or you can claim $1 million in damages as a result of the defendant's breach of an agreement dated August 1st, 1999, to supply 1,000 widgets to the defendant by December 1st, 1999. Which one gives you more information and signals to the judge what your case is about? It's obvious. I recommend the second. Parties, at page 11. A simple thing is describing parties. You can put in the plaintiff is a corporation, the defendant is a corporation, or at page 11 you can say the plaintiff, a corporation, corporate business laws of Ontario, manufactures computers from its plant in Toronto. Identifying the kind of work it does. And then paragraph 2 is even more important. The defendant, a corporation, is the only supplier of the widgets that are used in the plaintiff's computers in Canada. So now you've identified your central theme almost in the second paragraph before the court has even looked at the rest of the pleading. Then the next stage is what I'm trying to sell today, and that's the overview, the theory. If I could ask you to turn to page 17. And these are 3 examples of overviews that you would place in the pleading after the parties are described, but before the factual chronology. And the reason you put this in the pleading is because it provides the overview to understand the facts that are going to be pleaded. So, for example, at page 17, item 4, the vendor intentionally failed to deliver widgets to the purchaser, knowing that the purchaser would not be able to fulfill its obligations to deliver computers to his customers by January 1st, 2000, and would suffer damages including loss of profit and goodwill. A simple, straightforward theory that's easy to sell, and that may be as far as you want to go in your case. Or, the next one, the vendor failed to deliver widgets to the purchaser in breach of the agreement. The defendant knew the widgets were essential to the purchaser in order for the purchaser to fulfill its obligations to deliver computers to its dealers by January 1st, 2000. The vendor knew there were no other timely source of widgets available to the purchaser. The vendor knew the purchaser would not be able to fulfill its obligations to deliver computers by January 1st, 2000. The purchaser is not able to deliver the computers by January 1st, and the purchaser has lost profit and goodwill. Again, this one puts in the knowledge of the defendant, and that may be something that is important with regard to your theory of damages, because knowledge, as you know, results in greater damage loss that is recoverable. And then the other sample is at the bottom, at the top of 18. But you can get the idea that how you word this first overview paragraph can signal to the court what you think are the important aspects of your case. Now, I have another example at the end, which is actually from a real case, although the names have been changed and some of the numbers to protect the innocent. But I'm going to ask you to turn to the first 2 pages of the pleading. So I haven't got the page number. Page 240, the sample pleading. And you'll see that this is a claim by 2 plaintiffs, Landgone and Tarragon. Terra's from Gone with the Wind. And Streetwise, All Mine, and Bank are the defendants. And the plaintiffs, who are the owners, claim a declaration that a transfer from Streetwise to All Mine and and transfer. That is, it went from transfer to transfer in all mine. Register on title was a fraudulent, void, and unenforceable. And the application to amend the register on title was fraudulent and void. A declaration that the owners are the owners of the property as joint tenants. Setting aside the transfer. Setting aside the mortgage that's on title. That's on page 2. And other notice of security interest and an injunction and a declaration that there was fraud and that the director is not bound by what occurred in damages. Okay, so that's the essence of the claim. And I wanted you to read the parties, which is the next page. We'll see who the owners are and who the transferor is the person who sold it to himself and Street and All Mine, so that they became the transferees, and who the bank is. All right, so you have a general feel of the case. You know that someone's trying to set aside some kind of conveyance. You don't have a real idea what's going on, but you know that there was an amendment to amend the registers. You want to set aside that, and there's a mortgage on title. You want to set aside that. You want to get damages. Now I'd like you to turn to, I think it's the second last page of the paper, and you'll see the overview paragraph. I spent a fair amount of time on this paragraph, but that doesn't mean I couldn't and shouldn't have spent more time. But I want to read this with you to see if you have an idea from reading this how the facts will flow in the pleading. The transferor commenced and prosecuted a fabricated sham action against the owners, claiming foreclosure and possession of the property. The transferor did so intentionally, contemptuously, and fraudulently, filing false affidavits of service of pleadings and of motions in the fabricated claim, and taking default proceedings based thereon in order to steal the property. When the owners learned of this scam, they brought a motion to set aside the default proceedings and judgment obtained against them in the fabricated claim. While this motion was pending, the transferor placed himself on title by bringing the application to amend. Furthermore, while this motion was pending, the transferor sold the property worth $180,000 to the transferees, which included the transferor, for $118,000, and registered the bank mortgage in the amount of $87,000 on the same day. The owners wished to recover back their property with clear title. Does that give you a good idea of what's about to be explained? And the answer is it should. And if you look at what the facts are, there's a chronology that I've put forth just before the pleading at page 26. And you'll see there's a chronology of various events. And each one of those events can fit into that overview paragraph. And the suggestion that I'm putting forth to you is that that overview paragraph can be put into your pleading right after the parties are described. And that will help the judge understand the context and therefore every fact and how it relates to what you're trying to sell in your cause of action. And the same thing, of course, can be done in the statement of defense after the admit, deny, no knowledge paragraphs. So the question will be, well, how do you know that you're going to be able to maintain that pleading? Why wouldn't the court strike it out? And there's 4 things I have to say about that. The first is the rules on pleading are very clear, and that is that the rule provides where have I put my rule? I apologize. I thought I had it right here in front of me. The rule provides, and I'll take it right from the paper, the rule provides at page 12 of the paper, and the important words are that the pleading shall contain a concise statement of material facts in which the party relies for the claim or defense, but not the evidence by which those facts are duly proved. So, you must put in the material facts. You cannot put in evidence. But is there anything preventing you from putting in your overview? The answer is it's not evidence. Is it a material fact? Well, it certainly will give context to all the facts that are pleaded. The overview paragraph, in my view, is not prevented by the rules of pleadings. If someone wanted to bring a motion to strike, they would do so under Rule 25.11, which provides the court may strike out or expunge a pleading that may prejudice or delay the fair trial of the action. the overview doesn't prejudice or delay. As a matter of fact, it probably speeds it up. Is scandalous, frivolous, or vexatious? No. Is an abuse of the process of the court? No. Will judges like it? Yes. Will they want to strike it out? I don't see why. Will they think someone who's trying to strike it out is crazy? Probably. Now, the other thing is the appellant's factum. As you know, the rules have changed. If you read Mr. Justice Laskin's article about how there was an evolution that people used to, in criminal cases especially, put in an overview paragraph in their factum. And in the end, the court said, hey, it's not a bad idea. We should do it all around. And they amended Rule 61.11 sub 1. And they said, Part 2 shall contain a concise overview statement describing the nature of the case and of the issues. So, Rule 1.04 analogy, right? If they can put it in the factum, why can't you put it in your pleading? Then there's another case that I think might be helpful to you if anyone tries to strike out this kind of paragraph. Famous players and J.J. Turner. Mr. Justice Gale's decision, found in 1948 Ontario Weekly Notes at page 221. And suffice to say, he found that pleadings were meant to disclose fairly the proposition being presented by the party pleading, and that you could plead issues of law or legal propositions as long as you had the material facts. And all the overview really does is take the material facts and the legal proposition and blend them into one concise statement that will help you sell your case and help the judge understand it. So enough said as to why I think it would survive any motion. Now, it takes time, obviously, to develop this kind of theory for any case. Each case is unique, and you have to know the law, and you should be telling it, as you could see from the overview I did, from your client's perspective. That is, how your client saw it. Your theory, of course, could have an alternative basis. And, for example, you might plead that someone committed a fraudulent misrepresentation in the sense that they were reckless, not caring whether it was true or false. And so there's a degree there of whether they were reckless or was it negligent. And so you could have an alternative theory of negligent misrepresentation, and it is not really an inconsistent theory because it really was the degree of carelessness that would be the subject of dispute or decision at a trial. So those kind of theories are, although they are alternative, are not inconsistent. I highly recommend that you never have inconsistent theories in your pleadings or in your case, because inconsistent theories, each will detract from the other. In the end, neither will be very helpful to you. During the course of the proceeding all the way to trial, and even when evidence is given at trial, your theory may change. One or two words, maybe there'll be a better word, maybe there'll be an extra fact that you have to fit into your theory that you have to explain, or maybe one word will explain that negative fact. The amendments of pleadings, as I quoted from Mr. Justice Riley's decision, are really permitted virtually at any time. But the overview of your theory is the kind of thing you don't want to keep running to court and amending it all the time. My recommendation is you just write a letter to the other side saying, I will be amending the overview paragraph. I'm going to add to read as follows, changing these words, underline the changes, and I'll bring my motion at the beginning of the trial if you don't consent to the amendment of the pleading. And you may have 4 or 5 of those letters in your file as you change your pleading, but the last one's all that counts. And you don't have to worry about running back to court all the time to amend your theory paragraph, because you should have it available to you at any time, because the judge will love it. Now, having said all that, not every case needs a theory. If you're suing on a promissory note, and there's a promissory note dated such and such date, so much money advanced, interest, that kind of case, your theory is obvious. You don't need an overview paragraph for that sort of thing. But in general, for most of the kinds of litigation that appear to be developing or happening in our courts, that kind of theory or overview approach will help you to sell your story. The next topic I want to talk about, and I'm going to sort of switch now to a little more detail, is the advantages of remedy and what kind of things you can put into your pleading because of the remedy you seek. For example, if you're seeking an equitable remedy, then your pleading can plead all the facts you think would be of assistance to the court in the exercise of discretion to grant the equitable remedy. Those would all be material facts. And that gives you wide latitude to plead a lot of facts that otherwise you would not be able to plead in the normal pleading. So one example is equitable remedies or discretionary remedies. The second is punitive damages. And this one I think is extremely important because of what the Court of Appeal has recently done in the Whitten case, Whitten and Pilot, which case, as you probably know, is on its way to the Supreme Court of Canada. The reason it's important is it used to be the Curry decision, which is found at 1986 9 CPC 2nd at page 248, provided, and this was a case where an individual tried to get disclosure, tried to have the following paragraph in a pleading maintained. And the pleading said, the plaintiff says that the defendant insurance company indulges in a regular practice of wrongfully denying the claims of persons insured under policy of insurance which it has issued, thereby gaining for itself an unjust profit or gain. Basically, that the course of conduct of the insurance policy was to treat claims such as the plaintiff's the same way and asked for punitive damages, and Master Peppiatt struck that claim out in 1986. Well, in 1999, the Court of Appeal, in their wisdom, did two things involving punitive damages that I believe will open up this area of the law dramatically. Mr. Justice Finlayson talked about what kind of facts would be needed in order to obtain punitive damages and claim them. And he said as follows: moreover, all the cases that he referred to all reflect the concern of the courts with respect to objectionable corporate policies. And the trial judgments in 3 of these cases emphasize the need to force tortfeasors to disgorge profits for the action. It's part of corporate strategy, and so you need a form of course of conduct in order to justify substantial punitive damages. Well, that appears to be inconsistent with what the Curry case is all about. If you have to demonstrate course of conduct, then you're going to have to plead that the insurance company engaged in this kind of conduct, or some corporation had that kind of corporate policy. And what does that mean for discovery purposes? You get into all of the cases involving all those other claims, maybe a room full of them. But the Court of Appeal has said that that appears to be appropriate. The second thing the Court of Appeal did in dealing with damages, punitive damages, they said as follows: you need 2 things to get punitive damages. The first is the defendant must have committed an independent or separate actionable wrong causing damage. In the insurance case, there's a policy of insurance, which is a contract. The extra actionable wrong, independent one, was breach of the doctrine of good faith, that there's almost a fiduciary obligation involving an insurance company, and the breach of good faith was a separate independent tort over and above the breach of contract. And the court said, because you have an independent tort and there is malicious reprehensible conduct, we'll give you some punitive damages. And they reduced the $1 million to $100,000. Now, the reason this is important is that means when you're pleading for punitive damages, you can plead a separate independent tort for which you are not seeking damages. And the best example, you may recall in conspiracy claims, if you plead a conspiracy to breach an agreement and you plead the agreement was breached, the doctrine of merger applies, and the court says you can't plead conspiracy to breach and breach. All you need is the breach of contract. But now, if you're claiming punitive damages, you would also plead conspiracy to breach the contract, because conspiracy to breach, even though it merged, is an independent tort that would justify the first element necessary in order to claim and receive punitive damages. And so you now can plead the conspiracy, not for proving the conspiracy, but for justifying your claim for punitive damages. So that, again, opens up the kinds of facts you would be able to plead in a pleading, that is, conspiracy facts, if the facts are justified. And so I conclude by saying, why do this? Just as Rembrandt, after he completed the Night Watch with its perfect color blending to evoke specific emotions, when he looked at the completed work, when it was done, he looked at it and he said, this will sell. And it did. And he also had that feeling of satisfaction. And hopefully, you will have the court look at your theory of the case, say everything fits, the color is perfect, it's a beautiful picture, it's a picture of justice. and you'll be satisfied, and it will all be worth the effort. Thank you.
Well, thank you very much, Mr. Solmon. That was, as always, most enlightening and very helpful. We now have a brief, I think they call it refreshment break. I think there's coffee and muffins, that type of thing. And we will be resuming again at